Hi, welcome to another episode of GKtv. Today we are going to speak again, possibly for the third time, about affidavits. You have filed an originating process or a petition, or you filed an application, and there are affidavits flying between the parties until there comes a time when the registrar or the judge or the court of appeal is confronted with a pile of affidavits, each party saying the opposite thing. There are two ways of dealing with it. Let me tell you the first one. The first is to see whether you can credibly attack the allegations of the other side. For example, the other person says he's been oppressed as a shareholder in a shareholder dispute and that the majority shareholders have treated him in an abominable manner. So you have to show that that isn't so. So what do? You can say the obligation of the company and the majority shareholders is set out by company law as well as by common law. There are, for example, 7, and that you have taken time and effort to ensure that all those 5 obligations have been informed to the plaintiff or the petitioner. For example, you might say there were general meetings were notified to him in good time, that minutes of meetings were sent to him, that the agenda of the meeting was sent to him, that he was informed of the allotment of shares and he was given an opportunity to purchase the extra allotment of shares, and so on and so forth. That is a credible attack. That is decided in a 1980s Privy Council case of Tae Buk Chun versus Tahan Sang, where a person attacks another person's allegations credibly, then the deciding magistrate or the judge cannot make a decision on the point in issue. The magistrate has to abandon the point in issue and move on to another point, because there are opposing pieces of evidence that say opposing things, and the magistrate cannot come down to the one side or to the other. So that is the first method. The second method is something everybody is lazy to do but should do more often, and that is to apply by using the rules of court to cross-examine the deponent of an affidavit who's saying opposing things to what you're saying, when you are sure that he's not telling the truth. If, for example, he has made a previous statement which is inconsistent with the current statement, or there are documents which completely contradict what he says. If you do that and you bring him forward to the court, then you can discredit him in open hearings. It is not usually done, but it's better to do it, because it's better to challenge an allegation against you by an application to cross-examine. If you don't, and you leave it like this, and you carry on with your hearing, then the judge has no choice but to make a qualitative assessment of which evidence he or she thinks is more favorable to the one side or the other, and then to come down on that side of it. And therefore, do not let a situation arise where that risk occurs. Those are 2 points I wish to make to you. Number 1, make credible objections by way of an affidavit, and number 2, apply to cross-examine. Those are the 2 points I wish to tell you. Thank you very much and have a good day. Smash that like button, press subscribe if you haven't already, hit the thumbs up. Goodbye.